Hello everybody and welcome to the first ever vlog from your friends in the PI and clinical negligence teams at number 5 Chambers. My name's Jamie Gamble and this is hopefully the first of a series of short vlogs that we're going to be putting out in the future as and when there's something hopefully of interest for us to talk about. We've rather fallen at the first hurdle because no one yet has come up with even a half decent name for one of these vlogs. So if you'd like to suggest something that's not indecent in the comments below, we'll take it into account. I can't promise any prize other than our eternal gratitude and admiration, but I'm sure those are things that are worth having. Let me introduce the people who are joining me today to talk about remote trials and remote hearings and doing them by video and the practicalities of how that works. First of all, we have Rebecca Livesey. Her pupil master was John Coughlin, but despite that and him teaching her everything she knows, she's nonetheless overcome that hurdle to become a very competent barrister. Welcome, Rebecca. Say hello.
Hello, Jamie.
Hello. To give us the view from both the bar and the bench, at least until the Lord Chancellor realises what a terrible mistake he's made in his administration, Mr. Richard Adams. Hello, Richard.
Hey, Jamie.
Hi there. Dr. Neil Shastri-Hurst, who I understand, backs to some extent on the front line, aren't you, during this time, Neil, during the COVID crisis at time of recording? So wearing both your hats as a doctor and a barrister at the moment. How's all that going?
Not too bad, actually. Better than I anticipated. But,
okay. Oh, some good news.
Some good news. Evidently, they don't trust me on the COVID ward, so...
Okay, yeah, well, that seems highly sensible. Great. Welcome, Neil. And last but certainly not least, she spent 5 years in the Cayman Islands, but in the end could not resist the siren call of the return to the paradise of central Birmingham. It's Denise Owen. Say hello, Denise.
Hi, Jamie. Hi.
Hello, everyone. Thanks for joining me. So, remote hearings and particularly remote trials. I think maybe the first thing it's worth us having a talk about is your setup at home. We all are beautifully lit, try and show our best sides today, but there can be practical problems, can't there, in terms both of the hardware you or your clients have in this sort of situation and the actual software that you use. Rebecca, let's go to you first. What's your experience of issues that can arise in that regard?
There are obviously multiple issues because as counsel, we've obviously got to have notes as well as a webcam. You've got to have at least 2 screens functioning at any one time. I've done a number of telephone and video hearings via various different platforms, and on video in particular it's been difficult to know in advance how one gets different views. So for example, in some video software you can have gallery view or main speaker view, and it's worth knowing in advance on your setup which views you're going to be able to get. So for example, on apps, on most Apple tech, it's quite difficult to get gallery views, whereas it might be a bit easier on a Mac to do that. So it's something that I've had to practice in advance of hearings to make sure that my setup is correct and is going to work for things like cross-examination so that I can see the witness I'm trying to talk to.
Yeah, so to be clear about that, the difficulty can be, as I understand it, that if you have active view on an app, you just see whoever's talking, and whilst that sounds like a great idea, in fact it can take a few seconds to switch between people. If someone's coughs while someone else is talking, you can get the person that's coughing rather than, so it's better, we think, don't we, to have a more a setup like everyone can see that we're on today, where you can see everybody at the same time. Is that right?
Yeah, well, that's the problem. If I'm trying to talk to a particular witness and the judge makes a noise with his pen or something like that, having a full screen view of the judge instead of the witness answering your question while the tech gets around to putting your witness back on the screen is really not ideal, particularly when you're trying to assess whether or not someone's telling the truth. You've not got the normal body language cues that you do have in court. So what they're doing with their hands, for example, is often not visible. So looking at their face is even more important than before.
And so you do sometimes want to be able to see the judge roll their eyes while the witness answers a question or something as well, get an idea of how you're getting on. So yeah, I can see seeing multiple people would be a good idea. And you've got to think about that. The other thing that I've noticed, I've only done one actual hearing, but I've done a lot of conferences by video, is that also thinking about which way round your camera is, so being in landscape rather than portrait mode like we are. Think about where your webcam is on any device. So on iPads, they can be off to the side, so you end up like you're looking over in the corner the whole time, and things like that are all important to think about. Neil, what's your experience in terms of the sort of tech, and what's the best setup for you to use?
So I tend to have 2 or 3 screens up at any one time. So I
Okay.
have my main Mac screen, which I use for the video itself. I then position my laptop in front of that, so you can't capture it on the camera, but I'm then looking at the main screen whilst still being able to flip between my notes that are in front of me. And I often have a clean copy of the bundle off to one side on an iPad, although that's not absolutely necessary. I find it easy to have a clean copy, and as well as my marked up copy in front of me with my notes. And that means you're able to flip between all 3 screens, all in close proximity, whilst maintaining your eye view with the camera. So I think that's helpful. In terms of lighting, I tend to put a poised light behind the camera point.
Right.
That just lights up your face, as well as having, if you just have the overhead lights on, you can tend to appear quite dark on the screen.
Yeah.
And I think the other issue is if you're doing it on an iPad or a laptop, lift up the screen. I often use the white books or something to place it onto. Otherwise, you end up with this slightly demonic approach of staring down at the camera, and you look like something out of a Dracula film.
Yeah, I've seen more people's nostrils, the inside of, than I wish to over the last few weeks, I have to say. Lighting isn't worth thinking about, particularly when you get to mine and Richard's ages. I think you need fairly flattering lighting. Although for us, I suspect dark might actually be better than light. But cool. Okay, so you mentioned bundles there. Let's just follow up on that a little bit, because for primarily, I imagine, solicitors who might be watching this, how you approach digital bundles and so forth is going to be quite important. What's your experience of how good and helpful and usable bundles have been in court so far?
So I've seen a mixture, as I'm sure we all have. The most helpful bundles are, firstly, they're brief and they're limited to the key documents. Having very voluminous bundles are not helpful for the court, particularly if everybody's dealing with them in an electronic form. Secondly, having them paginated so that we all know which pages we're referring to, opposed to page 1 of 62 on PDF number 3 or number 4, is helpful. And thirdly, what I'm seeing an increasing trend of is that solicitors have already tabbed up the bundles. So it's very clear that we're all working from the same document. We can refer to tab 3, page 3 within tab 3, etc. Of course, there's an element of ensuring everybody is au fait with the software.
Yeah, that's probably a good point to bring in, Richard. And we've already complained about having seen full screen views of judges. So this is all without any disrespect to our wonderful judicial colleagues and leaders. But from your position on the bench, Richard, how do you finding bundles are working? I mean, I can see that bookmarking your Adobe files or your PDFs or whatever would be quite helpful, but everyone's got to understand how that works, haven't they?
Well, and also you've got to remember that just because you've got the latest tech at home doesn't necessarily mean that the judge will.
Yeah.
Unfortunately, a lot of courts simply do not have the technological capability to be able to deal with more advanced electronic bundles, for example, ones that have been fully tabbed up, helpful as it is. So I think weeks in advance, it's so important for us all to think about how the judge is going to be conducting the hearing. Is the judge going to have a hard copy? Is the judge going to have an electronic copy? There's no point in giving the judge an electronic copy unless the judge has got a compatible laptop with the right software on it. Without any disrespect to the older members of the judiciary, sometimes they do indeed prefer a hard copy. I know for my part, I prefer a hard copy, for example. So it's really important to make sure that it's legible, because one of the cases that I had consisted of a significant number of entries from social media posts. And unfortunately, they'd been produced in quite a poor quality fashion, such that when they were printed out, the date of the particular entry, which is critical, of course, when considering these posts, couldn't be read. So it's really important that you give some thought to how it's going to be produced and how the bundle's going to be used.
Yeah, I would have thought that's particularly true with photographs as well, isn't it? Because
Absolutely.
if you sort of scan a badly photocopied photograph, we all have these problems in real life as well as virtual life, haven't we? That if you scan a bad copy, no one can make anything of it. So actually having an original digital JPEG or the file sent to the judge so they can properly see it rather than the scanned copy is going to be pretty important, isn't it?
Yeah, absolutely. And just picking up on something that Neil had said, yes, in an ideal world, we would have 2 or perhaps 3 screens, but it's very unlikely that the judge will,
Right.
which I think makes it all the more important that the judge has got a hard copy as well as potentially a digital copy, because it's of considerable assistance to look at the hard copy, but also be looking at your screen, and you might not have the benefit of 2.
Sure. And having if you're doing a digital copy as well, I would imagine putting digital files together through a PDF editing software or something rather than trying to take bad photographs of documents and then it's going to be more helpful, isn't it?
Yeah.
Fine. Okay. Thanks, guys. So I think what we've touched on there is the importance of thinking in advance about things. It seems to me that's going to apply in a trial situation to clients as well, particularly. So Denise, I think you've done a fast track trial fairly recently. Do you want to just talk us through how that worked and how you found the practicalities of all of that?
Yes, absolutely. So for me, I would agree completely. The most important thing was logistics and planning and communicating with my solicitor at quite an early stage. So my solicitor had done a test of, we use Skype for Business for this hearing, and my solicitor had done a test of that with the client, ironed out, the client had both video and microphone issues and managed to iron those out in advance. I then did a conference with the client, a video conference with the client, and I was able to go through everything that I would ordinarily go through at court, but with some additional aspects specific to the fact that it was a remote hearing. So, for example, requesting that no one else was present in the room when the client gave evidence, making sure that if she did want to swear on a holy book, that she had that available to her, making sure that she had a copy of the bundle in front of her when she was giving her evidence. So that conference was very important. We also set up a messaging platform between myself and the client so that I could take instructions during the hearing. So, for example, when evidence was being given, I was able to take instructions quite seamlessly on my mobile phone from the client, and also I think it's quite important to be able to reassure the client during the course of the hearing. But then obviously during a conference, I was very clear about when and when we couldn't use that, and when she was giving her evidence, she needed to set that very clearly to one side so that she wasn't in communication with anyone. I also had my opponent's phone number, which I think is very important. So we were able to discuss in advance the logistics of when witnesses would be joining, and also when my opponent encountered technical difficulties, I was able to call him on his mobile and talk through those and restart the hearing. So for me, logistics were really important to make sure that the hearing ran as smoothly as it could do.
So preparation, even more so than usual.
Yeah.
And as I understand it, Chambers has set up their own sort of messaging system for this, so we'll be able to accommodate that, which would be useful in future. Rebecca, I think one thing that you raised with me recently was the fact that the court's own system can be a bit tricky in terms of managing clients. Is that something you found?
Yes, and it's dependent upon platform. So if Denise's hearing was by Skype for Business, you can obviously try that out in advance. One of my hearings, which was at the end of the hearing, was an infant approval section, was actually on the court's own cloud platform that they've been trialing, which of course you can't try in advance. My client had some difficulties with that, so I did all the things that Denise has done, spoken to the client beforehand, checked that their tech was working, but ultimately the platform depends on the availability of the court. So my client was in an absolute panic, trying to phone me saying, why isn't the hearing going ahead at 11 o'clock when we're meant to start? And unfortunately, the previous hearing had just run over a little, and the platform doesn't open up until the previous hearing is finished. So that's just one of the things that shows how important advanced preparation is in terms of everything that you can control, so that when something like that you can't control happens, at least you can reassure the client and phone the court and check that everything is still going ahead as far as you possibly can.
Yeah, and I would have thought it would make sense, wouldn't it? Even if you can't use the courts platform, you're probably better off having your pre-meeting with your client a decent time in advance by some sort of video platform, so at the least you know their webcam's working, they understand that they've switched the microphone on, you can see them, their Wi-Fi's working, and all those sort of things are ironed out in advance as far as they can be. Do you agree?
Yeah, absolutely. And it's about getting the setup as correct as you possibly can get it. So that if something goes wrong at the court's end, at least it's not your fault or your solicitor's fault or your client's fault.
So finally, I just want to talk about advocacy a little bit, because obviously both in interlocutory hearings and in trials, it's going to be a little bit different, isn't it? Richard, I think you had a good tip about something that's a bit different, which is about using people's names.
I don't think it's interlocutory hearings anymore, Jamie. You're showing your age there.
I'm very, very old. Sorry. What are they called now?
Hearings. Yes, I mean, it's even more important when you're doing a remote hearing that there's clarity in your submissions. I often find that it's a good idea to tell the judge right at the outset how many submissions you're going to be making. So, Your Honour, I have 5 submissions, number 1, and carry on through, and then say at the end, those are my submissions, Your Honour, so that the judge knows that you've finished. It's especially important in multi-party hearings where you might have 3 or 4 advocates on the call at the same time, so that the judge and indeed your learned friends know when you've finished speaking.
Yeah, and then to literally say, as you were telling me off for earlier when we were having a practice on this, to say, I'm addressing this question to, use the person's name or Your Honour or whatever, so people know who you're talking to, which is probably less obvious when you're not looking at them.
Exactly. It's even more important, because otherwise you do find that it becomes something of a free-for-all.
Right.
Unless the question is targeted to the individual concerned.
Fine. And presumably these days we're not supposed to address everyone in Latin anymore either. I get very confused by all these modern developments, but I'll have to look that one up. Neil, you, I think, had some thoughts about, as an advocate, whatever the sort of hearing is, how you should prepare for doing your advocacy. What are your thoughts on that?
Yes, I think there are a couple of points to be made. Firstly, we all have different styles of how we prepare for in-person hearings, but I think when we are dealing with video or virtual hearings, it can be more helpful to script your cross-examination in more detail. Time is of an essence in these hearings, and it allows things to be more focused and flow more fluidly. Secondly, when using documents or authorities, I think the court appreciates if you use those selectively. And you're focused in that approach. And thirdly, often we wouldn't prepare a skeleton for these sorts of trials, but in this case, it can be helpful to have set out in writing your broad position, because it allows the court to be well aware of where the parties stand in advance. And I found that's been seen as helpful by the judge, so we can cut through to the real issues and allow that any cross-examination to be very focused.
That sounds like a very good tip to me. Great, thank you. My dog's decided to say hello, which is also a useful tip. If your judge is a dog lover, you get your dog in the shot and it might help you. Thank you ever so much, everyone, for that today. That's been very helpful. Thank you to Neil, Rebecca, Denise and Richard. Just to let all of you know, if you go on the Number 5 website, there are a couple of very interesting and very up-to-date articles on there. Firstly from Rebecca on judicial early neutral evaluation and how that might work and the pros and cons of it. And also Neil's done an article on the ways in which the courts might approach the standard of care in clinical negligence cases during the COVID crisis in the future, which is something I think all of us who practice that area are going to have to start wrestling with probably sooner rather than later. So we'll try and put the links to those below whatever platform you're viewing this video on. Thank you for watching. If you have any questions, please do put comments or queries to us on whatever social media you're using. If you have any other ideas for future topics for one of these vlogs that you think might be helpful, please don't hesitate to let us know. But until the next time, thank you again to everyone, and we'll see you soon. Take care. Goodbye.